Hi, everybody. Welcome back to BHBA Family Law Presents Direct Examination with Dan and Lauren. Along with Lauren Youngman from Youngman Reitshtein, I'm Dan Bemel, financial advisor and certified divorce financial analyst. And thank you all for joining us. During our time together each month, we'll explore our guest's personal and professional history and dig into a meaningful legal topic. On our upcoming episodes, always the first Wednesday of each month at 12:30 p.m., we'll be joined by Judge Thomas Trent Lewis in May, Ann Kiley in June, Judge Lawrence Riff in July, and Dana Lowy and Doreen Olson in August. The sign-up links are available in the chat box and on the bar calendar. Before we begin today, a few announcements.
Thanks, Dan. You will receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that's included with your certificate. Program materials were emailed to you, and you can find a link to the materials in the chat as well. The Family Law section is sponsored by Soberling, White, Zuckerman, Warsofsky, Luna, and Hunt, and Our Family Wizard. Soberlink's system combines a portable breathalyzer with wireless technology. Trusted for use in child custody cases since 2011, Soberlink is the only system that combines court admissibility in all 50 states and Canada, facial recognition and tamper detection, real-time results, and easy-to-read advanced reporting. Trust the experts in remote alcohol monitoring technology for your custody cases involving alcohol. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Finally, Our Family Wizard. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. All right, thank you to our sponsors. Dan, let's begin the program.
Okay, thanks, Lauren. And you all know our guest, and we're so excited to have her with us, Laura Wasser. If you've listened to or read Laura in the past, you know how passionate she is about making structural and systemic changes to the process of divorce. So we're going to talk about that from a few different angles today. Laura's advocacy style with her clients, today's legal topic on obligations to opposing counsel, her online divorce platform, It's Over Easy, her book, It Doesn't Have to Be That Way, and her podcast, Divorce Sucks and All's Fair. It's a lot to get to. I'm sure we're going to cover even more ground. So let's get into it. Laura, welcome, and thank you for joining us.
Thanks for having me, guys.
Okay, this is going to be great. So let's start with, I'm kind of curious. Let's start with your own advocacy style and some of the things that separate you. And I want to pick up on something that was at the end of that New York Times profile last week. What changes for you, if anything, when someone is in their second or third time around as a client and going through the process again?
Oh, well, I mean, if a client is a returning client, I often will know them and have knowledge of their business acumen, their pain threshold, how they process information. You know, some clients are more business oriented and they handle the case as a business transaction, where others may need a little bit more hand-holding. Also, if they've been through it before, then they kind of know a little bit about the process and the system, and generally they are kind of easier to guide. You don't have many people who go through miserable multiple divorces. They'll have a miserable first divorce, and then they say the next one was so much simpler because I just came to it knowing so much more about how to approach this. So I think that's it. I mean, the familiarity, you know, with our members of the firm and the client, but also their familiarity with the family law process.
So is there a difference, whether it's the first time around or second, third, fourth time around? Is there a difference in your style or the work itself when the client is well known and has some degree of public profile?
I would say the only difference is, and you all know this, we take a lot of our cases out of the system. And we definitely have done that during this past year of the pandemic, because the private judges with whom we work are able to do a lot via Zoom and get things processed. And so we have been very busy over the last 13 months. And even though when you have a private judicial officer, you still have to file the documents downtown, you can do it in a timely way that maybe they won't get picked up as much. Also for custody cases, we tell celebrity clients they need to be a little bit careful of paparazzi, unlike you or I, they're not going to get photographed coming out of a club or a restaurant. We're not going to get photographed coming out of a club or a restaurant, weaving if we've had a few too many drinks, and they may. So that would be something. And then I think the other thing is, I think a lot of those people are not really used to being told no very often. And we as family law practitioners have a pretty easy and clear set of laws. And so when someone comes to us and says, well, I'm famous and beautiful and wealthy, and therefore I should certainly have sole legal and physical custody of my kids. Whereas everyone else might have said, well, of course you should, because we're getting a percentage of everything you make being beautiful and powerful and wealthy. We family law practitioners need to say that's unlikely to happen. And your kids have a right to have custodial time with their other parent as well. And so let's see if we can work something out that makes sense.
So over the course of your career and your experience, how has your advocacy style changed, if at all?
I think it has not changed a lot. Obviously, in 26 years, I've grown and learned. I learned a lot. Many would assume it was from my dad, but really the person who taught me my advocacy style was his late partner, David Rosenson. And David used to always say, and I say now as well, like, we're problem solvers. So it was like putting a puzzle together, figuring out how you were going to get a judicial officer to see it your way, to a narrative that makes sense, that's bite-sized enough so that they can understand it and so that they will hear the story that you're telling and find hopefully for your client. And so I think I've probably gotten better at that over the years, gotten a little bit better at reading judges. I see many attorneys when we are in court, and I've been in court in the last few weeks, believe it or not, downtown at Mosque. And you can see that the judge is messaging things either by his or her facial expressions, which is not easy under a mask, or their commentary. And so being able to read that and see where they're going and where they might want you to go. And Judge Gordon said to me a few years ago, it's so interesting how many lawyers keep talking even after they're winning, and sometimes talk me out of going in their direction because they're continuing to try to convince me. And then I realize something that I wouldn't have otherwise realized, and I change my tentative. So I think that's a really important thing for people. And I've tried to get better at that with age as we practice and be able to read judges.
And do you think that can only be gained from your own personal experience, or is it something that you gained from watching other attorneys practice, or a mix?
Probably a mix.
What about when you're in the mediator's chair? I know you've been doing more and more of that. Does your approach to a case change, or to your interactions with the other parties involved?
Absolutely. Because as a mediator, we have to be much more neutral and maybe not as aggressive in terms of taking a side. Because otherwise what you find is that you start being a little bit two-faced. I mean, you're yes, I totally agree with you. And no. So more neutral. And I've really tried to take what I've learned from the amazing judicial officers who have gone into mediation and emulate their styles, because I've really worked with some amazing ones, and they are closers, and they will go that extra mile to get it done. Sitting in the room, typing up an actual mediator's proposal, spending that extra time past 5 or 6 p.m. on a Zoom call with us. Those guys are amazing. And so if I could ever be half the mediator or neutral that they are, I would be thrilled.
Have you brought things from that experience, sitting in that neutral seat, back into your adversarial side?
Yeah. And it's really cool. I mean, also sometimes I'll sit as a judge pro tem. So it's the same type of a thing where I'm like, well, how would I feel if I was at counsel table right now and taking, things that you learn? I mean, it really does. It helps shape perspective. It was one of the things that I loved about law school is you read these cases and you see both sides of a story. I think when you're a neutral, you get to do that. And then that will hopefully help in your practice as well.
When you work as a neutral, as a mediator, do you take a more active role in suggesting solutions, or do you try to encourage the parties to come up with ideas more on their own and facilitate settlement that way?
It depends if the mediation is assisted by counsel. So usually if it's by counsel, it's going to be two lawyers that I've known for a long time. So I trust them to provide, whatever the solutions are, the way that their client wants them provided. If it's just the parties, then yes, sometimes I will write up a mediator's proposal, or I will really be much more active in saying, how about this for a solution to this problem?
So let's go back a little bit. You teased out how you learned some of your advocacy style. So I want to maybe go back even further when you started. We all know a little bit about the story because you've been so open in so many other forms about your history and joining your dad's practice. But when did you know that was going to happen? I mean, I know I've heard you talk about the acronym in your name. So it was kind of destiny from the beginning, but take us through a little bit of that about how you came back into family law. I think people will find that very interesting.
Okay. So I did not think I was going to be a family law attorney. I didn't even think I was going to be a lawyer, but my parents told me that they would continue to support me as long as I was in school. And I certainly wasn't going to go to medical school. So I applied with my rhetoric major from Cal. I applied to law schools and I got into a couple, and I went to Loyola here in LA. And I really liked law school, but I still didn't think that I was going to go into practice with my dad. I mean, that's just so conventional. Why would anybody ever want to do that? And then I got married after my second year of law school. And then after I took the bar, we kind of realized that probably wasn't the best idea. We were really young, 25. And so very amicably and with very little or no assets, probably just debt, we split up. And I had been working at the Western Law Center for Disability Rights while I was waiting for my bar results. But that was kind of a nonprofit situation, and I really needed a paycheck. So I went to Dennis and David and Susan Carter at the time and said, could I work here while I wait for my results? Because I need some money to pay down this credit card debt. And they reluctantly said yes. And so I started working there. And first of all, it is good money. I tell law students that all the time. We actually bill in a good way and we make good money in family law. But the other thing is, it's fascinating. And I guess if you're attending this webinar, you know that you get to learn all about people's lives and you get to learn very intimately. I mean, I know things I never would want to know, and I would never know about even friends of mine for 10 years. But for some reason, when you're a client in a family law case, you're vulnerable and you want to tell your attorney everything, sexual proclivities, your deepest, darkest fears, dreams. And so you really get to learn very much about these people, and you get to kind of be their spirit guide through what is a pretty generally crappy experience, and you get them to the other side. And that's what I really like about it. That's what kept me doing this for so many years, because it's fascinating to me, this study in human nature, while at the same time being able to really help people. And that's why, we get kind of a bad rap as divorce attorneys, but divorce attorneys are people that are problem solvers, and they really are leading you through an unhappy time to your next chapter. And I think that's really cool.
So when did you start thinking about putting yourself out there more? I mentioned at the top, the book. I mean, I want to talk a little bit about the book and the podcast first, because that is not something that a lot of attorneys do. Where was that kernel? How did that start for you?
So I wrote the book in 2012, 2013, really. It came out, I think, at the end of 2013. And the reason I did it is because at that time, I had so many friends that probably could not afford Wasser, Cooperman, and Carter, or Mandles, as we've become. But they would ask me questions all the time because they were at like the 10-year mark in their marriages and they didn't know. And I really thought, why is it that when you're paying these high fees, that's the only time you should have access to this information? So I wrote the book, and it came out and it did well. And I still was not putting myself out there, actually. I really did not feel comfortable. We had always had a no media policy at the firm. I didn't think that it was cool to kind of capitalize on other people's unhappy, legal situations. And so we really never gave interviews. We never talked about anything. We have a media line that we put press into. Just no, no, no was always like our motto. And then in 2018, when we launched It's Over Easy, one of the marketing people said, one way that this will work is if you are able to market it, if you are able to go out and talk about it. You've been doing this for 20 some odd years. You have credibility. Let's get you out there. And so that's kind of when I started. And again, I still won't talk about any of my cases or our clients or anything like that, but being able to kind of spread a message. I mean, there's not much that I'm good at in this world, but family law is one of the things that I've been doing for a long time and I know a lot about. So if I can speak about that, and if there's a way, we call it the evolution of dissolution, which is a way to change how people approach divorce, I'd love to see that, because it is interesting that in the entire time I've been practicing, and even going back to when I was a kid and I would listen to my father, he would say the same things that we're saying now. Why haven't we evolved to make it an easier process for people?
Well, tell us a little bit more about your thoughts about the process and the way the system is set up now, and what you think maybe should change about it.
Well, I think we are doing a better job in California than I'm seeing in some of the other states. California and New York State are really the most, but they're behind us. Mediation centered, the collaborative law that we do here, coming to the table with the two people who know the most about the family dynamic. One of them should know a lot about the family finances, and the other should be educated about that. And really taking those people and educating them in order to be able to apply the laws in our state to their situation and coming up with a resolution on their own is key. Because as we've all seen, if a couple settles their case, they may not love the settlement. Nobody's going, yeah, I totally won this. But the win in family law is not spending a ton of money on attorneys and a ton of emotional and personal angst on this process, which is so frustrating. I mean, our system is broken. And I know that our legislators and administrators are trying to fix it, but it's going to take a long time. We hit a major road bump in 2020 with the pandemic. And so even getting down into a courtroom to have something done, the case log was already overwhelming for most judicial officers. And so taking it back into the family's own hands and being able to help them resolve it, I think that's one of the best things that we can do. And it is changing. And some of the custody, kind of presumptions, so to speak, are changing. I mean, there's still in other states, people assume that mom's going to have the kids and dad will see them on the weekends and on Wednesdays. But that's not how we come to the table here. But that's all really recent change. And again, I have nothing to do with it, but I applaud it. But I feel like there needed to be change. And I'm hoping, people really get more into therapy. Almost everybody that comes into our office is already in some kind of mental health, therapy or counseling or something. And I recommend that for everybody, because I really do think that in tandem with going through what you're going through as a business and a legal transaction, your heart's breaking and there's humongous change with your kids and who you're going to go to the Labor Day picnic with and who's going to, provide health insurance and all this stuff. You need to be talking to somebody about that, and not somebody that's billing $300, $400, $500, $600, $700, $800 per hour. So I think those are the changes I'm seeing. And of course, I would like to see more. I would like to see it because everybody regards divorce as such a huge taboo. And the fact is that if half of the population is getting divorced in any given state, and those are still the numbers, it shouldn't be so, oh my God, a divorce. Because it's happening. And it's happening when people are still an age where they can get divorced and raise their kids co-parenting peacefully and then going on to perhaps another relationship. And so let's be mindful of that and figure out the best way to get them through it.
So is the accessibility thing, you mentioned the dollars per hour, like that's expensive for a therapist, but not necessarily for a lawyer, right?
Right.
So let's call it the accessibility gap to get counsel. Obviously it's over easy, and I want to dig into It's Over Easy a little bit more, but when did you first start focusing on that in your career and really that becoming an issue or a cause that you cared about?
I think when I started working with Betty Nordwin at the Harriet Buhai Center for Family Law, you really see so many people. I mean, imagine if English wasn't your first language, you hadn't gone to law school, and now you're like in a situation where you don't know who's going to pay the rent. Maybe there's some domestic violence going on. You've got little kids that you have to feed and clothe and diaper, and you're going through this. I mean, it's terrifying. It's terrifying for everybody, but it's really terrifying if the forms aren't printed in the language that you speak and the judges don't speak the language that you speak and you can't get a lawyer. So when you work with some of those people, men and women, you really do see the need for some kind of an access to justice system. And Buhai provides that, Levin and Quinn provides that, Los Angeles Center for Law and Justice. This access to justice piece of the puzzle is really, really important. And what I've said before is that divorce is the great equalizer. Everybody's terrified, everybody's heartbroken, and everybody is, I mean, you know, top studio executives, super intelligent and powerful people will come to me and say, I'm really sorry, but I have no idea what the divorce process is. And I would say, well, why would you? Okay, why would you know that? Right. So everybody is somewhat, you know, discombobulated. We're trying to help them, but you have all these other factors against you when you have somebody living below the poverty line. And so we have to figure out a way to assist those people because they have the same problems. It's Over Easy is probably for a little bit higher of a socioeconomic group, you know, people that can afford $1,500, $2,500 for an all-in divorce. But again, access to justice, forcing people to kind of take the laboring and it's an online mediation platform. So figuring out the law, applying it to your fact situation, and then coming up with a resolution. That's the kind of thing that I think probably anybody should be doing. Obviously, there's some complex issues in family law, move away cases and, you know, tracings of separate property and commingling. Absolutely. But the garden variety dissolution can probably be handled by the parties with some assistance. And so that's kind of what got me thinking about it, was my work with Buhai and then writing the book, which was kind of for more people that were my age at the time and how they were navigating it. And then we came up with this because I thought it needed to be available to people.
So how did you actually land on that as the solution? What was the genesis of the site and of the platform?
I think it was having written the book, which was kind of here's what you can expect. Remember the books, what to expect when you're expecting when you have kids. This is kind of like what to expect when you're divorcing. So laying out what the steps might be in terms of how do I deal with separation? How do I deal, and what is the date of separation? Or how do I exchange the financial information? How it seems overwhelming, but when you really think about it in terms of here's what I make, and here's what I spend, and here's what I have, and here's what I owe, which is basically your PDD, your I&E, and your schedule of assets and debts put together, and you're filling those out and you're exchanging them. I mean, in many relationships, not both parties are aware of what the financial situation is. Wealthy and poor people, now they get to know, they figure it out. So I guess the genesis was just knowing that people wanted this kind of information and then providing it to them and seeing what would happen.
And now that you have the platform out there, what have you learned from it? And has it had an impact at all on your own practice?
It hasn't had much of an impact on my own practice, except for that when we decided to do the platform, we made it really holistic. So in addition to just having the forms that are provided, we also have a lot of education about it, which was easy for me to pull together because I have to give that to clients anyway. And then we have something that's called the index, which is a listing of all kinds of service providers to help people during and after the process. And we've all known this for years, which is, the people get divorced and then they still need to change their will. They still need to get health insurance after their COBRA ends and it's no longer available through their spouse's employer. Childcare, going back to school, all of these things we give listings for in any given state. And I feel like that's helpful. And I knew that was stuff we needed to know because I've helped, young dads. They're like, okay, great. You got me custody. Now I don't know what to do with my kid when I've got him 50% of the time, putting together, play groups for men, for dads, that kind of stuff. But I never really realized how much of a thirst there is for that in the community that's kind of going through that process. So that would be one thing I learned. I don't know that I learned anything new about it from doing it, but I definitely learned that there is a need for it. That's for sure.
What has the reaction been to the platform from the family law community, whether it's the bench or the bar or some of the legal aid organizations that you mentioned?
The legal aid organizations have been welcoming. A lot of our peers have said, like, why are you cannibalizing us? This is what we do. But for the most part, particularly people in this bar association have said, thank you, because I never have anywhere to send clients that can't afford me. There was a big delta between, for example, BuHi and, some of the other great family law practitioners in town. And we fit that niche. So when I said to them, like, I'm not trying to cannibalize our industry. What I'm trying to do is have somewhere where we can send those people. They've kind of gotten it. And the bench has all been really, really receptive. What I've heard from many judicial officers is, I wish there was a way that we could get them to It's Over easy before they end up in our courtroom. By the time they're in our courtroom, they've already filed their documents pro per and they're showing up. So I wish there was a way. So we're trying to think about that and figure that out too. Because again, if you have all of these people that are pro per, that is kind of what's glutting up the system. If we could help them before they ended up taking that day off of work and trudging down to mosque and sitting there and waiting, that would be fantastic.
So what do you think are the next steps for either the platform itself or your overall access mission in opening up access to the process?
I mean, I don't know. I still have my day job. And I do have 2 kids too. I mean, we're trying to just kind of, we don't have a huge budget to spend. It's mostly self-funded right now. And we are not, we're barely breaking even. We want to just continue to, build a client base, word of mouth. Obviously, if there is the Google ads that we do, I want people to be aware that it's available. We are in all 50 states. But I do think that there is a certain wariness to A, doing it yourself, and B, doing it online. Like, remember the days when we'd be like, oh my God, I would never file my taxes online. That's so scary. It's the big internet. Everybody could see, or I'd never give my credit card number to Net-a-Porter. How could I do that? I could get hacked. Now people are more, I would never date online. And now people are kind of coming around to that, and they're willing to sit down at a laptop and kind of enter in information if they know it's going to ultimately be less expensive, both emotionally and financially, for them to get through their divorce.
So I want to shift gears a little bit to something that we sort of touched upon earlier, and it blends into the legal topic that you picked for today. So starting off, what is your opinion on the level of civility in the family law bar today?
My opinion is that we could be doing much better. I feel like, and I've spoken to others, within the bar about this. I understand why the clients have high level of anxiety and can be really ugly towards each other. I don't understand why we are. And when I was a young attorney, I think it was Arlene Schwimmer said to me, you and I are going to know each other a lot longer than you and that client of yours. So you and I need to get along. And she was so right. I mean, I was like an aggressive little, but she was so right. And I have many dear friends that are colleagues. We send each other cases if there's a conflict, and we can really work well together to facilitate resolutions for our clients. But there are those who, for whatever reasons, are going through whatever they're going through, whether it was pre-pandemic or certainly during. There is a very high frustration level with the fact that courts have been closed, and with the fact that things aren't moving, and with the fact that clients have, you'll probably remember at the beginning of COVID where everybody was putting the brakes on their custody because, well, you can't go between 2 homes, and he doesn't wear a mask at his house, and her boyfriend is out at a, party in the backyard, and I don't want to send my kid there. All of these things, we were getting calls. And of course it seeps into you. And so you get frustrated. And when you're talking to a lawyer on the other side who says, I don't know what to do about it. I can't control him, whatever, that can be frustrating. I get it. However, unless we're able to get along with each other, we are doing a disservice to our clients. And I do think that there have been some colleagues who maybe thought this was, the Last Supper, and they had to really get every nickel out of whatever this client was. And so there was probably, fee churning. I think people have taken advantage of some of the clients and what they're going through, taken advantage of the fact that the court system is moving kind of slowly, taken advantage of the fact that our judges are really rotating more than they did in the past. And I think I'd like to see that change. I don't know exactly what we can do about it, but I think that things go more smoothly when we are civil to each other.
Have you seen a change in your experience personally over time in the level of civility with opposing counsel?
Yes. And it started before COVID, but it definitely worsened during COVID. And we've all discussed it. I mean, yeah, and I'm not totally sure why. When I started practicing, and this is in the early 90s, there was this kind of group. It was a relatively small bar. Everyone knew each other. You could kind of do things with a handshake, even though you were advised not to. A person's word meant something. There was a certain level of integrity. If you had a telephone conversation, it wasn't essential to immediately bang out a confirming letter because you knew the person and you knew if you made an agreement with them, be okay. I don't see that happening as much anymore. And I don't know why. And I don't think that there's any one person or firm to blame for it. I think we've become kind of more litigious within our group. And I think maybe we are teaching our younger attorneys a different, maybe more aggressive and not as civil way to deal with things. I think we've seen some cases come up in the last even few months that show that. And I think we can do a better job for our clients if we are able to get along with each other. There's just no question about that in my mind. I also think as practitioners, our quality of life is better if we're getting along with our colleagues. Who wants to wake up every morning at 5:30 to a nasty email? I mean, it just doesn't make sense. Why would you get personal about somebody's situation when you're just doing a job, with them?
And in your practice, what do you do when you're confronted with an attorney who's behaving not very civilly, or they're being very aggressive, sending off those angry emails that are, you have to scroll down to read the whole thing? How do you approach those cases and address that issue?
I try to let it roll off. I'm not always great about it. My dad always said, never let them see you sweat. If you lose your cool when that's happening, then you've kind of lost the battle. So you try to rise above it. You try to do what is best for your client in terms of not engaging. They don't want to read a bunch of letters that they're being billed for with you and the other person getting into a pissing contest. But it's not always easy. And again, we tell, now I'm in a situation at my firm where I have 4 or 5 young attorneys that I'm kind of mentoring and trying to get them to learn how to do it what we think is the right way. Our firm has always kind of frowned upon personal attacks or, getting engaged in some kind of, mudslinging. So when I see that happening, I'll try to intervene. You do a good cop, bad cop thing. I also really think that the judicial officers that I've spoken with can read between the lines on those things too. You attach exhibits that have a bunch of nasty emails going back and forth. They're reading it and they're thinking, these morons, what are they doing? They're billing their clients to write mean letters to each other. So I think you have to really try to rise above. I think it's better for you, for your heart and your blood pressure. And I also think it's better for you just in terms of professionalism.
So a lot of the cases that you selected in the 2 code sections touch or deal with the appropriateness of sanctions, when to get sanctions, were they upheld, were they overturned? How do you decide when that is an appropriate remedy or when it's really worth taking things to that level during a case?
So we don't often at our firm make sanction motions. And I'm sure somebody that may be listening will correct me, but I can't think of a time when we made a sanction motion against the attorneys. I mean, as you all know, you can sanction the client, but then you actually sanction the attorney too. We kind of have always come into this, even if there's opposing counsel that we don't love, with the opinion like we have a club, we have a group, we have to upstand a certain level of professionalism, and we're going to do this the right way. In terms of sanctions, we have asked for sanctions against clients. Mostly it has to do with frustrating the settlement process or the discovery process. If somebody who's really not giving us documents and we can't get the information any other way, we'll first start with a production request. And if they don't come back, if we take a depo and we can't get the information there, if we've exhausted all other possibilities and we really do think that we're kind of being played with, then we might file a sanction motion. Lauren was saying earlier before we came on, a lot of the judges see so many of them that it's kind of like ex partes. They just barely even read them now. And they just kind of go, this is your problem. We don't want to deal with it. I can't opine on whether that's right or wrong. I think it's obviously a case by case, but it's kind of like the boy who cried wolf. If everybody's always asking for sanctions, it kind of doesn't, and they're never getting granted, it kind of doesn't really have as much of a sting when they do. I would actually prefer to see judicial officers, even on the record, admonish. I hear a lot, oh, you have to go out in the hall and meet and confer. But how about really I've read over this. I've read your sanction motion. I'm not going to make a sanction order, but this is really tell us how you're feeling, because I think the clients need to hear it too. And then maybe can say, I don't need the dog and pony show or the chest beating. Just can we get through this simply?
So do you think that more judicial intervention in cases where they're very contentious would be helpful?
I think more judicial intervention and I'm fine for a judge to tell me what he or she is thinking about something. I really go on what they are saying about that. And if I'm hearing that will direct how I will direct my client. I know that they're too busy. I know they can't intervene as much as maybe they would like to, because I'm sure they're all dedicated individuals who want to do a good job. We have a few cases right now that even though they're in the system, we've hired an out-of-system discovery referee who can be really helpful, and they are, and that does move things along. But again, that becomes prohibitively expensive to have a discovery referee at every third-party deposition and at every home inspection or whatever else. It is expensive, and you have clients going, why do we need this guy here? Now there's a whole nother person that's making calls. They eventually understand why it's helpful. But again, if you had the home court judge saying, you better figure this out, and really, instead of always trying to be so neutral and fair and whatever, calling some of us out, I think maybe we would get more of the results that we are looking for.
And in your experience, I think you were talking about a little bit earlier before we started the show that judicial officers maybe used to be more involved because they had been on the bench longer and sort of had an understanding of what to expect from certain repeat appearances from counsel. Can you talk a little bit about that?
Well, I mean, we all know we kind of have had a revolving door of family law judicial officers in the last, 10 years? When I started practicing, there was the same 10, 15 judges who had been there forever. They knew most of, the usual suspects that would come down. If somebody was a repeat offender, he or she would probably get slapped for that. And the judges, they may have been more arrogant. There might have been a panel of, old white Jewish guys that were judges, but by the same token, they did have the balls to say, this is what we're doing and you need to stop this and whatever. Again, the caseload wasn't what it is today. And I think that definitely the bar wasn't as big as it is today. But also, I think when you get new judicial officers, and God bless them for even coming to family law, and I know they're doing the best that they can do, but if you have somebody in front of them who's been practicing law 10, 15, 20, 30 years, of course, the judicial officer may be intimidated, may be listening, may be more respectful of that person, that attorney, than they would be if they had been sitting on the bench for that many years. And so, it's a quandary. I don't know that there's much we can do about it. I hope that some of the just new judicial officers we have now stick around for a while, because it seems like they're good ones. But again, that has been another shift that I've seen in the long lifetime that I've been doing this now.
Okay, so let's bring this back to your practice.
Okay.
And again, go as deep as you want to go here. On one side, the bad behavior, right? Maybe talk about some of the worst offenders you've seen, so we know kind of what you're getting at. And then on the other side, what do you do when you're put in that situation, when the client is trying to get you to write a scathing letter or run into court for an order, or, I mean, obviously you could just say no, but how do you actually manage that piece of the case?
So let's start with that one and work backwards. I mean, that happens all the time. And like I
Yeah.
said, when you have wealthy, powerful, famous clients that are used to being told yes, it's even harder to be the person that tells them no. And I do say, even in the first interview, listen, I'm not going to blow sunshine up your ass and tell you that I can do something I can't. I'm good at my job, but the law is the law. And here's how I see it. And then as the case progresses, of course, you have very angry people. You have them wanting you to be their advocate and their mouthpiece. And I just had a conversation with another attorney the other day who she had said to me, look, I know there's nothing I can do. This is what she wants me to go down and ask for. And so I have to. And I said, kind of being like the old, granny attorney, I said, if you continue to practice that way, you're not going to enjoy what we do, because you have to at some point be the voice of reason for your client and say, no, I'm not going to go ask for that. It doesn't make sense. We won't win. If we did win, it would be appealable, and it burns a bridge with your ex and his or her attorney. And so we're not going to do it that way. You got to trust me. We got to do it this way. Now, obviously that's easier to do if you've been practicing for 20 plus years, because you've got some credibility and you can say that to clients. And if you're a younger attorney and maybe your client isn't listening to you, if there's an older attorney at your firm that you can go to, whatever. But remember, we went to law school. We took that terrible California bar. They're paying us a lot of money to tell them and give them the benefit of our wisdom, not just to go in and create, a dog and pony show. And so you have to remind them of that. And again, I had a client the other day who was really upset with me with something that a judge ordered. And she said, I'm not going to do it. And I said, you are going to do it. And we had an argument, and then she hung up on my face, and then she called back a little bit later and apologized. I said, but you're going to do it, or you're going to get another attorney who's going to let you not do it. And then you're going to have those repercussions. So yes, you can just say no, but I do think that they deserve an explanation as to why.
So you want to dip your toe in the bad behavior water?
Well, I'm not going to give examples. We've all seen it. We can all tell our war stories, but in some of these cases, like Levine and Moore, and you've got them in your case materials, the amazing thing to me is that some of these attorneys are rude to the judge too. And I'm sure we've all had a moment where in court and we're sitting at counsel table, or maybe just in the gallery, and we're like, holy shit. Because now you've got an attorney who's gotten so fired up. She or he is not just saying horrible things about opposing party and opposing counsel, but now they're telling the judge. And in these cases, the judge said, one of them was Levine is an attorney's duty of candor. This attorney actually sat there with a straight face and did not tell the judge. It was like a lie of omission that the sale had already happened. And the judge writing the opinion said, that's not okay. You have a duty as a officer of the court to tell this judicial officer that this happened. You can't just sit there and not say anything. And then in Moore, it was really bad because the guy was rude to the settlement judge, rude to the judge, yelling, screaming, intimidating. That's not okay. And yes, those people need to be taken to task. Of course, it's good for us to be kind and civil and professional to each other, but when you take it out of bounds and get it to the judge, and it's amazing to me that even happens, but it does.
What about when the judge is bad, like in Tharp, right? Right. I mean, that's a real different twist on it. And the judge, in the end of that case, that was a pretty good smackdown on the judge. Yeah, of that judge.
And I'm sure we've all had moments where we're like, does this judge hate me? Why is this happening? When you try because if you're losing, it's bad enough. But if you're losing and the judge is kind of, making comments about you or ignoring you. Yeah. But, again, we pick our judicial officers, or they are picked, and we are hoping that they are neutral, and we are hoping that they're professional. And is there maybe some that come in with a predisposition against somebody or are turned off by somebody? Yeah. I mean, I remember when I started practicing, Rosenson was like, cover that tattoo, take out those other earrings. You no pants in this firm for women. And I was like, okay. And, and obviously that's changed a little bit. Getting older, I can probably wear what I want now to court, but you never know what the judicial officer is going to think about your appearance or something you've said either in your paperwork or at counsel table or your clients. And so you have to really watch that. But yes, there are times when the judge isn't good. It's not often. And when that happens, you have to really take a deep, hard look, maybe get another person from your firm or another co-counsel to say, like, am I insane here? Or is this person really disliking me? And then figure out what to do about it, like they did in Tharp. I mean, the Court of Appeal found that judge was really, really biased, and that wasn't okay.
So when you have a biased judge, there's very little, I guess, that you can do about that, short of appeal. But what have you implemented or what are you doing at your firm to institutionalize the right way to approach these cases with younger attorneys?
I think even from the hiring of them, and obviously we don't do a ton of hiring, there's only 16 of us all together, but we look to people who seem to have a certain amount of integrity and poise. It's been a little bit more difficult over the past 13 months because although we do our attorney meetings via Zoom, we're not seeing everybody. I've been perfectly happy to work from this living room. It's lovely. And my kids are remote school and we can all have lunch together. And I've billed more than I've ever billed in my career because I'm not driving over the hill to the valley to pick them up. I'm not driving down to court. I'm just here. That being said, I do think it's important that we all get back into the office at some point, because one of the things I enjoy about being one of the managing partners at our firm is that my door is open and they can come in and they can ask and they can talk. And even if I weren't, even if it was just, me and the other attorneys at the firm kind of shooting the shit or having coffee or talking about it, I think that's an important component. I mean, unless you're a sole practitioner, and even then you have probably other attorneys you talk to in study groups and in some of our bar association meetings. I think our community is a very important part of what we do and being able to commiserate and learn. So I really make sure that the young attorneys understand, and this did come from my father, the resolution-oriented way of practicing law, that our job is to help these people resolve as amicably and cost effectively as we can. And that's what we're here for. And if that's not what they want when they hire us, then we probably send them somewhere else. Really, we do. It's not how we roll, so to speak. So everyone that works at our firm knows that. And when we do have our firm meetings, we will often discuss cases, opposing counsel, what's happening, what's the right approach, how to do it. And I think that most of the attorneys at our firm, the younger ones particularly, would say, yeah, that's how we feel comfortable practicing. And that's how we know that we can achieve the best results, whether we stay at Wasser, Cooperman, and Mandles forever, or we go out on our own, or we go to another firm.
So on the business side of practice, and this is something we talked a lot about with Chris on our last episode, what do you see on the horizon? And, we have a few minutes left. I'd love to wrap up with your thoughts on family law as a business. You alluded to that a little bit earlier, and just not only just developing the skill set of the next generation, like you just talked about, but the business side for you and the firm and the community as a whole.
I think that if we are not embracing as a community and as business people, this Zoom situation, even after, we will get left in the dust. I think that even our courts have been a little bit slow to, as we've all tried to do the LA Court Connect and the WebEx stuff, but we as private practitioners can certainly do that. So I think that's really essential. Because I don't think it's going away. I think a lot of people are going to continue to be working from home to a certain extent. I would caution them, as I said before, not to isolate yourself too much, because I think the sense of community is important. And I hate to sound so rah-rah about it, but mediation. If we really continue practicing in a single-minded litigation mode, I think that those people, with very few exceptions that have to do with these high net worth, high complex cases, are going to get left in the dust. There is enough business for everybody to help by virtue of mediation. And I really think that achieves the best results for the clients.
Do you think that, to go back for a sec, do you think that adversarial system is and almost the a little bit of a reticence to go the mediation route for whatever reason. Do you think that's actually one of the roots of the problems that you cited when we were talking about the cases or civility generally?
It could be. I mean, I'm not sure. I will also say, like, people that have been leaning towards collaborative divorce and then have said, I'm not going to do that because it means that I then would have to start all over again if we weren't able to work it out. I've seen that reticence, that maybe that's too far on the side of being able to get along and work through it. And I don't have an opinion on that. I just know that certain clients have strong opinions on it. I do think it's important that we have an adversarial system, in that if you can't resolve it, you have got to have a tiebreaker. You've got to have somebody that is the voice of reason, that knows the law, that can say, okay, this is what's going to happen. So I think that's important. But I think rushing to that has caused its own problems in our system. And I feel like that's why it is so overwhelmed at the moment, particularly.
So, and also looking forward, when it's safe for everyone to be going back to court, do you think that remote appearances are here to stay, especially in family law, with parties, witnesses, counsel, all appearing at home on Zoom? Or do you think there'll be a big return to going in person?
I think that remote appearances are going to continue. I think remote trials or evidentiary hearings are difficult. And I have had judicial officers tell me that. I mean, I was in court the other day and my client was with me and my client's wife was on the telephone. How do you know she's not looking at notes? How do you know she's not texting with one of the other attorneys? I mean, I think that's tough. When you're remote on camera, fine. I also think that because of the technological issues that we have with that courthouse in particular, I think it's going to be difficult and frustrating. But I certainly think, showing up for a trial setting conference, showing up for, a continuance, that why wouldn't we continue doing that remotely? That makes a ton of sense, just like court call always did.
Okay. I think we have a few more minutes. I'm not sure if there were there was one question in the Q&A that I can bring up before we wrap up. So someone asked, how do you balance children and the practice of family law? My children?
Oh,
that could be anybody's. Probably.
No, so, well, there's a lot of drinking involved, not for the children, just for me. And for those parents out there that are trying to, my kids are a little older now. They're almost 16 and 11. So they are a little more self-sufficient. But, there are days that I just think I've completely failed as a parent. I'm the worst mom because I was on a Zoom settlement conference until 7. I heard them eating dinner. And there are days that I think I'm the worst lawyer because I, missed writing something or doing something. You have to just give yourself a break. You are doing 2 super important jobs, raising your family and then helping another family get through a difficult time. And, you're going to have bad days and good days. Sometimes you'll go to bed going, I nailed it today. This is amazing. I did everything I was supposed to do. And then you wake up at 2 and go, oh my God, I think I had an appointment with the dog groomer and I didn't take them. So it does get easier. You do kind of get into a rhythm, and this year threw everybody for a bit of a loop. I wouldn't schedule court appearances on the days that, I was driving carpool, those kind of things. And then you go outside and there's a nail in the tire of your car. That happens, and we're all human, and you just have to kind of give yourself a break. And of course,
is that your best advice for the younger attorneys that are listening and watching today, is to maintain that balance, or is that only come later in your career?
I was lucky. I had my first kid when I was 36. I was not a partner yet, so I still had people to answer to. The thing is that we all kind of know, yes, if you're in a firm setting and you've got the senior partners and everything else, I think from the firms that I know, we are all so much better now about maternity leave and making sure people have childcare. And we're not going back until September at the earliest in our office, because it's great that people have been vaccinated, but we still have kids that are home from school or home from camp this year. So I think this generation of parents may have it a little bit easier because of what we all went through. But in terms of maintaining the balance, you kind of just get through it and know that you're doing the best you can, and ask for help. That's another thing. Really important to ask for help. I do think that if you ask colleagues, friends, co-workers for help, they will help you more than you ever can imagine. People like to help. That's our nature as family law attorneys. So we're a good field to be able to go to for help within our own.
That's a really good point. Something that I think a lot of us take for granted or don't think about, but it's true. That's ultimately what we're doing, helping people. And on that note, that's quite a nice positive note for us to wrap up. Thank you, Laura, so much for joining us.
Thanks for having me. I loved it. It was fun, and I hope somebody besides Neil got something out of it.
Right.
Yeah.
It was a really great discussion. Everyone, please mark your calendars to join us for our next episodes on May 5th with Judge Lewis, June 2nd with Ann Kiley, and July 7th with Judge Riff, and August 4th with Dana Lowy and Doreen Olson. They're all at 12:30 p.m. Registration links are posted on the BHBA calendar. Thank you to Genna and Alex at the bar, the Family Law Executive Committee led by Carrie Holmes and Ron Reitshtein, and of course to our section sponsors. And once again, thank you so much, Laura, and everyone have a great rest of the week. We'll see you next month.
Thanks, guys.